Hi everyone, it's Doug Eisenberg with a brief review of my Domain Name Dispute Masterclass videos available here on YouTube and also on my Gigalaw website. In the series, I go into detail about all of the elements of a robust plan to defeat cybersquatters and protect brands on the internet. But in this video, I'll present just a very high-level summary of the Masterclass series, focusing on what I hope are the essential takeaways. So, without any further ado, here is my top 10 list. Number 1. Cybersquatting is a real problem for trademark owners. It's been a problem since the creation of the World Wide Web, and it's only getting worse. In recent years, we've seen a record number of domain name disputes filed by trademark owners against domain name registrants to deal with issues such as counterfeiting, phishing, and traffic diversion. Number 2. Going to court to fight cybersquatters is time-consuming, expensive, and complicated. Yes, traditional trademark infringement laws are helpful, and some countries, such as the United States, have even adopted specific anti-cybersquatting acts. But like most litigation, it's not something that anyone, from individuals to even the largest companies, really wants to get engaged in. Number 3. The UDRP, or Uniform Domain Name Dispute Resolution Policy, was developed in the late 1990s by ICANN to provide a quicker and less expensive legal process for trademark owners to deal with the growing threats posed by cybersquatters. It's become an incredibly effective tool, with trademark owners winning about 90% of all UDRP cases. Number 4. UDRP proceedings are similar to arbitration, except the entire process is conducted online. As a result, the time and expense of motions, hearings, discovery, and appeals is eliminated, and the typical case only takes about 2 months, usually resulting in a decision ordering transfer of the disputed domain name to the trademark owner. Number 5. UDRP proceedings are also very inexpensive, requiring only the payment of a filing fee to one of the 6 ICANN-approved UDRP dispute providers, and if an outside attorney is used, a legal fee. Filing fees at the most popular service provider, WIPO, the World Intellectual Property Organization, currently starts at $1,500, and other providers are even less expensive. Number 6. A trademark owner's UDRP complaint is evaluated under a 3-part test. To have the disputed domain name transferred, it's necessary to prove all 3 elements. First, that the domain name is identical or confusingly similar to a trademark in which it has rights. Second, that the alleged cybersquatter has no rights or legitimate interests in it. And third, that the domain name was registered and is being used in bad faith. Years of precedent are available to provide guidance on interpreting and applying this 3-part test. Number 7. Most UDRP complaints involve only one disputed domain name. But if a case involves multiple domain names held by the same alleged cybersquatter, they can be addressed in a single complaint, making the process even more efficient. The largest UDRP on record, which I filed in 2009, was for more than 1,500 domain names. Number 8. Cybersquatters employ many tricks to avoid being detected or identified, such as using fake names and contact information, or registering via privacy or proxy services. Plus, the European Union's General Data Protection Regulation, or GDPR, has redacted many registration details for privacy reasons. But despite these challenges, the UDRP is still the best option. Number 9. The URS, or Uniform Rapid Suspension System, is another domain name dispute policy available to trademark owners, but it generally applies only to the new top-level domains and not, at least as of this recording, to .com, .net, and .org. Plus, it only allows a trademark owner to get a domain name temporarily suspended, not transferred. Number 10. Although some countries have adopted the UDRP for their country code top-level domains, or ccTLDs, such as .co in Colombia, other countries have adopted a variation of the UDRP, or a different dispute policy entirely, while a few countries don't have or enforce a policy at all. So that's it. My domain name dispute top 10 list to give trademark owners a big picture understanding about how to deal with cybersquatters. I've been helping my clients with this issue since the mid-1990s, and I can tell you that the UDRP is without question the most important and useful tool out there. But knowing when and how to prepare and file a winning UDRP complaint is one of the most important decisions that a trademark owner can ever make if it hopes to combat cybersquatting on the internet. For more details about any of the topics in this top 10 list, as well as much more, I hope you'll watch some of the other videos in this masterclass. And to learn more about domain name disputes, I invite you to take a look at other resources on my website at www.giga.law, where you can also subscribe to receive a daily email newsletter about important developments in internet law. Thank you for watching.